Good evening, and welcome to the 7th Feddie Night Fight, brought to you by the Federalist Society Student Division and the Federalist Society at The Ohio State University. My name is Brett Baker, and I'm president of the Federalist Society Student Chapter at Ohio State. I have the privilege of introducing tonight's distinguished fighters and our honorable referee. Tonight's topic has been discussed in FedSoc circles for some time, and we're excited to bring the debate on common good originalism to one of FedSoc's biggest stages. First, calling the balls and strikes, the Honorable Paul B. Matey. Paul B. Matey is a circuit judge on the United States Court of Appeals for the Third Circuit. Prior to his judicial service, Judge Matey was a partner at Lowenstein Sandler, where he practiced complex commercial litigation and criminal defense. He previously served as Senior Vice President, General Counsel, and Secretary of University Hospital, Newark. Judge Matey also served as Deputy Chief Counsel to New Jersey Governor Chris Christie and as an Assistant U.S. Attorney for the District of New Jersey, where he received the Director's Award for Superior Performance from the U.S. Department of Justice. Earlier in his career, Judge Matey served as a law clerk to the Honorable Robert E. Cowan of the U.S. Court of Appeals for the Third Circuit, and to the Honorable John C. Lifland of the U.S. District Court for the District of New Jersey. Judge Matey earned his B.A. from the University of Scranton and his J.D. summa cum laude from Seton Hall University School of Law. In support of common good originalism, we have Josh V. Hammer. Mr. Hammer is an opinion editor of Newsweek, a research fellow with the Edmund Burke Foundation, a counsel and policy advisor for the Internet and Accountability Project, a syndicated columnist through Creators, and a contributing writer for American Compass. A frequent pundit and essayist on political, legal, and cultural issues, Josh is a constitutional attorney by training. Prior to Newsweek, The Daily Wire, where he was an editor, Josh worked at Kirkland and Ellis, and he clerked for Judge James C. Ho on the U.S. Court of Appeals for the Fifth Circuit. Josh has also served as a John Marshall Fellow with the Claremont Institute and a law clerk for Senator Mike Lee of Utah. Josh received his B.S. from Duke University and his J.D. from the University of Chicago Law School. And finally, against common good originalism, we have Whalin, Ed Whalen. Mr. Whalin is a distinguished senior fellow of the Ethics and Public Policy Center and holds EPPC's Antonin Scalia Chair in Constitutional Studies, where he directs EPPC's program on the Constitution, the courts, and the culture. As a contributor to National Review Online's Bench Memos blog, he has been a leading commentator on nominations to the federal courts and issues of constitutional law. Mr. Whelan is a former law clerk to Supreme Court Justice Antonin Scalia and is a co-editor of 3 volumes of Justice Scalia's work: Scalia Speaks, Reflections on Law, Faith, and Life Well Lived; On Faith, Lessons from an American Believer; and The Essential Scalia, on the Constitution, the Courts, and the Rule of Law. Prior to joining EPPC, Mr. Whalen served as a Principal Deputy Assistant Attorney General for the Office of Legal Counsel in the U.S. Department of Justice, and as General Counsel to the U.S. Senate Committee on the Judiciary. In addition to clerking for Justice Scalia, he also clerked for Judge J. Clifford Wallace of the U.S. Court of Appeals for the Ninth Circuit. Mr. Whalen graduated with honors from Harvard College and received his J.D. magna cum laude from Harvard Law School. Now, at the end of this evening's debate, we will open up the floor for questions from the audience. You must be logged in as a participant in the Zoom webinar in order to ask a question. Please use the raise hand function in Zoom to enter the queue. When we get your question, Judge Matey will call on you by name, and the Zoom host will unmute your microphone so you can ask your question. If you are calling in from a phone, you can press *9 on your phone to raise your hand. And with that, I will hand it over to our honorable referee, Judge Matey.
Brett, on behalf of the entire panel, thanks for that kind introduction. I know I speak for both Ed and Josh in saying it's always an honor to join so many future friends at a gathering of a FedSoc student chapter. Even though I have to admit, it's been a bit hard for me to believe that it's been over 20 years since my first student event. Forgive the detour, but it's amazing how little has changed. Sure, the pamphlet I found tacked to a bulletin board wasn't very flashy. I remember wondering, could I really sit with the foremost thinkers in the law just by putting a $5 bill in the mail? That's how we did it back then. It was true. And so with creaking voice and trembling hands, I got to stand in rooms with Antonin Scalia, Clarence Thomas, Robert Bork. The list and the memories run long. But memories are usually a poor guide to history. They can trick us into a false sense of the past, one, for instance, that takes too much for granted. So it might be with the enormous contributions of thinkers like Judge Bork and Justice Scalia. or what prompted their thoughts. Turn back to the early 20th century when the ravages of war, unemployment, and moral decay spread rampantly, opening the door to the always tempting cry to do something. As a result, the kind of amateurs who first framed our republic, led our public institutions, fell into disfavor, and soon enough, so did neutral interpretations of the law, another casualty of the progressive era. It was all replaced by a sea of indeterminacy later known as fundamental rights, substantive due process, a more searching inquiry. That's the world that existed for more than 40 years. This is the world that shaped a young Robert Bork writing in 1971 about a constitution focused on meanings that text or history showed the framers actually to have intended. That sentence would become a wave that would push legal thinking over roughly another 40 years back to the shores of originalism. And it's a reminder that today we might not remember that all of this didn't happen easily, because we sit near the summit of a mountain of theory and thinking that a generation of scholars has devoted their lives to puzzling through. We have it easy. Type originalism into Westlaw and dozens of cases will pour forth. Puzzled by the process of interpretation, read Scalia's treatise. Doubting how to cite history, reach for Thomas. It may be 20 years since my days as a student, but those 2 decades have brought us far enough to be far too comfortable. As modern students of originalism, grounded in restraint and humility, we stand on the shoulders of intellectual giants. So we are mindful before cutting away at trees that grew into this forest to remember what stood there before. But fond memories can equally blind us to our own errors. Sources misread, assumptions poorly grounded, equivalency falsely found, or perhaps the belief that nothing more can be added to the best methods of interpreting the law. Lives, even ones lived so very well, do not last long on earth, so we cannot know with certainty where the incomparable minds of Scalia and Bork would have taken originalism. But we do know that their minds were wide open. Justice Scalia often remarked that originalism was merely the best available option. And Judge Bork candidly wrote that if there was evidence that the framers and ratifiers intended judges to apply natural law, well, then he would accept that judges had to follow. Tonight, Judge Bork's challenge is accepted as we consider common good originalism, a theory that argues for a more substantive zone of interpretation in the originalist inquiry. Leading the call is Josh, who grounds his arguments in the conservatism of Hamilton, Marshall, Joseph Story, to advocate respect for constitutional text informed by constitutionalism's roots in natural law. Answering the bell is Ed, who sees peril, not promise in this theory, noting the long struggle fought to return the law to a predictable, neutral, positive course. Is now really the time to change direction into the unknown? Are errors in the application of originalism grounds enough to indict the entire enterprise? Both will help us answer what comes next. What is the goal of originalism today, and how can recent and distant events sharpen our memories and improve our appreciation of the enduring legacy of Scalia and Bork? We'll start this evening with Josh, allow Ed to counter, and then give Josh a few minutes of rebuttal. With certainty, a lively exchange will follow, and we'll turn to the questions from the audience at the end. With that, the floor is yours, Josh.
Okay, well, thank you so much, Judge Matey, for agreeing to moderate this. Thank you to the Federalist Society for hosting what I'm a little biased, but I think is a very important topic here. Thank you to Ed. We had a very similar debate for the Heritage Foundation maybe 2 weeks ago or so. So great to see you again, albeit virtually this time. Due to time limitations here, I'm going to cut right to the chase. From my perspective, the conservative legal movement, much like the post-World War II conservative movement in general, has failed us. Our leaders have oftentimes failed us. Those who are responsible for guiding our movement have let us down time and time again. The definition of conservatism obviously is contested by many, but going back to Edmund Burke, John Selden, John Fortescue, the great common law thinkers, Koch, Blackstone, those but even before Burke, we obviously can place some sort of value on conserving something. And my first question that I think of when I think of the conservative legal movement, especially in the modern era, when we kind of use that term and toss it around, is what exactly have we conserved? There are two areas of law that I can pinpoint as us conserving something, or at least coming close to conserving something. One, of course, is the Second Amendment. Justice Scalia's name is going to be batted around tonight a lot. Of course, DC versus Heller, one of his finest hours from my perspective. McDonald versus Chicago follows 2 years later. Even on that issue, though, of course, as you know, the very informed audience here is all too aware, the shadow docket, we are very often, we have literally not gotten 4 votes for cert on any meaningful Second Amendment related issues since the McDonald case of 2010. We see what's happening on the Ninth Circuit with respect to concealed and open carry, nothing that seems to be coming on our radar. Religious liberty is kind of the other issue that I can point to as a jurisprudential success in the abstract. However, this kind of gets back to an exchange between, I guess, technically Ed's now boss, although he's so much younger, Ryan Anderson and David French last summer. This kind of gets to a point that they made. And Ryan's counter to David on this point was that even though conservatives are consistently winning, quote unquote, on religious liberty at the Supreme Court, it is the time in litigation of people like Jack Phillips being subjected to court in the first place and the uncertainty that necessarily follows from litigation that kind of also kind of renders that quote unquote victory from a jurisprudential standpoint something less than that. So I think that we, by and large, have failed. The question, of course, is why is that? Now, as a conservative, I look at what our jurisprudence actually is. And there's a lot of people who have kind of written about the kind of evolution of modern originalism since kind of the modern founding fathers, Justice Scalia, Judge Bork, Ed Meese, those like them, first formulated. I actually pinpoint a National Affairs article that my friend Elon Werman kind of wrote when he was clerking for Judge Jerry Smith on the Fifth Circuit back in 2014. And he kind of pinpoints, I think this is an accurate kind of nomenclature, is an accurate taxonomy, if you will, of originalism. He pinpoints conservative originalism, which is kind of the first wave of originalism. And this first wave of originalism, most frequently associated with those like Justice Scalia, like Judge Bork, is avowedly positivist. Now, of course, those two luminaries kind of fought voluminously over the years with those like Harry Jaffa of the Claremont Institute, those like Hadley Arkes. With respect to whether there is any sense whatsoever in considering quote unquote non-textual sources, whether concepts of natural law, of moral values, really period, outside of the words, the document, play any role in constitutional interpretation. Of course, the Declaration of Independence, the preamble, those sort of things play into that exchange. Then you have libertarian originalism, which at some point in the past 15, 20 years has, from my perspective, become the overwhelmingly predominant form of originalism, certainly in the Federalist Society speaking circuit, arguably from a pedagogical perspective in the legal academy. That theory is most closely associated, of course, with those like my friend Randy Barnett of Georgetown University Law Center. And there are many others, but for purposes of simplicity and purposes of time, I think we can kind of distill the essence of so-called libertarian originalism as being the subtitle of one of Randy's earlier books. This is the so-called presumption of liberty. The notion here that when in doubt, when in kind of the confines of what some new originalist scholars call the so-called construction zone, we tend to err on the side of individual liberty and individual liberty maximalism. You see that in instances like the Ninth Amendment, the Privileges or Immunities Clause, any number of constitutional provisions where those like Professor Barnett, who himself personally wrote favorably in favor of the Lawrence versus Texas decision of 2003, my friend Ilya Shapiro of the Cato Institute wrote a quote unquote originalist amicus brief in support of Obergefell versus Hodges in 2015. You see this kind of presumption of liberty playing out over and over again in libertarian originalism. Then you have finally progressive originalism, to the extent that's not an oxymoron, most closely affiliated with Professor Jack Balkin, which is less my concern, but to the extent that I've kind of delved into it, seems to basically just imply that the original public meaning of various provisions, the Eighth Amendment's cruel and unusual punishments clause being a good example, effectively delegates moralistic judgment to future generations to kind of implement it. So they kind of get to Dworkinian living constitutionalism via originalist mechanics. Now, as a conservative, I look at that and I say, where's the actual conservative jurisprudence here? Where is the jurisprudence that values the timeless conservative values of justice, human flourishing, and the common good, the likes of which are very clearly emphasized in these 7 substantive ends of governance enumerated in what I consider to be our very common good-oriented preamble? Establish justice, promote the general welfare, secure the blessings of liberty for ourselves and our posterity. Not secure liberty, by the way, secure the blessings of liberty, insofar as liberty is just an instrumental means and the substantive end is the actual blessing. So I look at that and I basically say, where are conservatives getting their jurisprudence here? And I think I think what's happened over the course of the past 30, 40 years is we have allowed kind of positivists and libertarians to kind of join at the hip together and kind of promote this kind of ahistorical kind of Jeffersonian strict constructionism, a term that many leading originalists, to their credit, have tried to disavow. But I think implicitly that's kind of still what we're getting at. And we're trying to basically, or what we've been told is that a lot of provisions end up getting construed very narrowly so as to minimize government and promote liberty at any and all costs. Taken to its logical conclusion, my claim is this kind of avowedly positivist, strict constructionist form of originalism leads to literalism, the likes of which we saw from Justice Gorsuch in the Title VII case, the Bostock case from last term. So because we're so brief here in introductory remarks, I'll save the rest of my time for rebuttal, but the essence of common good originalism, as I see it, is one, I take a claim of Burkean epistemological humility and basically say that originalists have oversold over the course of decades the extent to which every single provision has a quote right and a quote wrong answer. I think the founding fathers' debates themselves kind of evince that is so often far from the case. You can look at the Helvidius Pacificus exchanges, of course, between Hamilton and Madison in the early Republic. Just read the transcript of the first Congress. They disagreed on everything. So we start from Burkean claims of epistemological humility, which necessarily will kind of widen the contours of what new originalist scholars call the construction zone, the zone of permissible interpretation within originalist confines. And then the question is, within the construction zone, what do you do from there? Now, I expect Ed would say that you just try to get to the right and correct answer, kind of similar to kind of Justice Thomas Lee's Corpus Linguistic project. At that point, though, I would say it is wholly proper and appropriate and is kind of the essence of judging in a true Hamiltonian, Marshallian sense to kind of orient your ad hoc judgments to what I would call the telos, the purpose of the American regime, which is best expressed from my perspective in our very common good oriented preamble. So I'll cut off my very short intro remarks there and save time for rebuttal.
Josh, thank you for that. Ed, we'll turn it over to you for a response.
Thank you very much, Judge. As someone who is often fairly accused of being a half glass empty person, I'm amazed to hear Josh say that the conservative legal movement has failed us. What a short history span that comment reflects. When we look at the last 30 years, what we see is the incredible rise of the conservative legal movement. And we need to have in mind that until 2018, Justice Kennedy was the critical fifth vote on the Supreme Court. So nothing could get done without his vote. So what we're looking at is the last 2.5 years in which we've had Justice Kavanaugh replace Justice Kennedy. And then just in recent months, this incredible replacement of Justice Ginsburg by Justice Barrett. We are in as strong a position as we have ever been. I don't want to be complacent. There are battles ahead, but what a strange time to declare failure. Now, Josh is right to outline these seemingly these different flavors of originalism. What I would argue, and what I think various advocates of these flavors would also agree to, is that no, there's one originalism. You can dispute subsidiary methodological questions, but originalism is designed to ascertain the meaning of legal text at the time that it was adopted. Now, often that text will not be clear, and I agree with Josh that original meaning often does not yield clear answers. It often excludes a lot of very bad answers. Roe and Obergefell, I believe, clearly fail the originalist test. But there's plenty of room for progressives to argue that some provisions should be interpreted in a way that's consistent with progressive results. There's plenty of room for libertarians to argue, again, using the same methodology as progressives, using the same methodology as conservative originalists, that some provisions advance libertarian goals. And likewise, there's plenty of room for conservatives to argue that some provisions should properly interpreted reflect and implement conservative values. The key to all these things, I think, when originalism is done properly, is originalism is a methodological tool that is ideologically neutral. Now, some people bristle at that, but the question to say that originalism is ideologically neutral does not mean that the legal text that is being interpreted is ideologically neutral. So fortunately, we live in a country, say, unlike Nazi Germany or the Soviet Union, where we can expect that texts properly construed are going to promote justice, or at least give people the capacity, the freedom to work to promote good policies through the democratic processes. Now, Josh puts a lot of weight on the preamble. The preamble is part of the Constitution. I'm perfectly fine, and where it's appropriate in figuring out how it ought to come into play. I really wonder when that would be. I mean, you take the first of all, let's have in mind that the preamble was part of the original Constitution, obviously before any of the amendments. I think it'd be strange to say that those amending the Constitution were somehow required to filter their amendments through the preamble, and that unless they've done so, the preamble casts some sort of permanent light on them. But beyond that, the preamble of the Constitution isn't that different from the preamble to the Articles of Confederation. It's a statement of very general principles that explains why, for example, we have a system of separation of powers, why presidents have 4-year terms, why senators serve for 6 years, why we have these two houses, why Congress's powers are enumerated. And it's not as though you can look at any provision of the Constitution and say, aha, if we interpret it this way, this is clearly the way to promote the general welfare and secure the blessings of liberty. And I think it's it's fantasy to think that the preamble is going to provide any meaningful guidance in 99.9% of cases. I'm very supportive of Chief Justice Marshall's opinion in McCulloch v. Maryland. Nowhere does he use the preamble in the way that Josh proposes. It's simply not there. Like Josh, I think that Justice Gorsuch's false textualism in the Bostock case is a huge mistake and deplorable. But do we think that Justice Gorsuch would have had more difficulty reaching that result if he were asking what is necessary to establish justice, form a more perfect union, promote the general welfare? Those are not constraints at all. Look, I think the originalism that I would propose, again, aims to neutrally determine what the meaning of provisions was at the time they were adopted. I supplement conservative originalism with principles of judicial restraint, which means that where the originalist inquiry does not yield a sufficiently clear answer, you defer to democratic processes. Libertarians, as Josh indicated, are instead likely to invoke this presumption of liberty, which is to override the democratic processes when the answer isn't sufficiently clear. Progressives will, use the running room to advance the progressive agenda, and I guess Josh would use the running room to advance what he sees as his agenda, which, frankly, I'm really not clear about. And I guess I'll just close with the observation that I don't really understand what common good originalism really means. Sometimes it sounds like something very, very modest, where we just look at the preamble in cases where it might make a difference, in which case I'm all for it. Sometimes it's presented as though it's some grand reform or corrective. But let me just say one last thing I should say. Josh uses the epithet positivism. Look, I believe strongly in natural law. What he calls positivism is simply the understanding that in a system of separated powers, it is for legislators to pursue their best understanding of the natural law. Legislators include the drafters of the Constitution, and it's for judges to say what the law means. So this elementary separation of powers, yes, confines the judges and justices to a certain role, but insofar as the provisions that are enacted embody natural law understandings, then of course it is the duty of the justices to give those effect. I think that what Josh is really offering is a conservative form of Dworkinianism that is as ill-founded as Dworkin's own appeal to his own moral intuitions. So I'll leave it there, and I'm sure we'll have a lot more back and forth on this.
Thanks, Ed. Josh, why don't we start by you taking a quick response to some of Ed's points, and then we'll open it up for dialogue.
Sure. Yeah. So I think there's a lot of confusion as to what common good originalism is. That's largely natural because I haven't fully fleshed it out yet. There will finally be a long form academic article next month that hopefully kind of answers a lot of these questions. I get accused a lot of times of being kind of a closet right Dworkinian. Evan Bernick, in all his fulsome charity and his tweeting, has accused me of that. I actually think common good originalism is a profoundly more moderate, more modest jurisprudential stance than kind of the overt right Dworkinianism of Adrian Vermeule. And Adrian's a friend of mine, to be clear. But in Adrian's kind of opening salvo in that Atlantic essay a little over a year ago, when he outlined common good constitutionalism, I purposely intended common good originalism to try to be kind of a halfway point, if you will. In Adrian's own response to common good originalism, he accurately noticed that. So I do think this sits well within the confines of originalism. I'm really not advancing anything as beyond what Judge Matey said in his opening remarks. Is kind of a more kind of Anglophilic, common law, historically rooted kind of Hamiltonianism. It really is a jurisprudence of Chief Justice Marshall in the McCullough versus Maryland case. A lot of people, a lot of critics tend to say, Ed here himself, said that Chief Justice Marshall does not talk about the preamble. In McCullough, that's really of no particular relevance to me, actually, because for two things. One is it's just kind of a historical matter. I think a lot of this was actually just done implicitly. A lot of kind of early Republic era judging, and not just judging, but kind of legal interpretation in the other two branches as well, of course. Before judicial supremacy kicked in, legal interpretation, of course, was ubiquitous in Article 1 and Article 2 as well. And constitutional interpretation at that time was understood as necessarily being oriented to our Anglo-American constitutional order, which goes back to the roots of the common law. What was the common law based on? Well, this kind of gets back to some of my criticisms of the conservative legal movement in general, is that I think but I'll hold that aside. But the common law itself, you can't understand the common law without understanding the Bible. What do we think common law judges were trying to do? They were trying to kind of get to establish justice and the various aims that are right there in the preamble. That is kind of the essence of Hamiltonianism, Marshallianism in general. Okay. So I think there's just a lot of confusion here. I think of common good originals being very profoundly based in the original public meaning. What I do, though, is I do kind of take this epistemological humility point and basically say that we should be candidly willing to concede that there are more plausible, reasonable, originalist interpretations than many would other times be willing to admit. And in cases like that, I think that the constitutional interpretation, and not just the original Constitution, I actually disagree with that. I think future amendments, and not just future amendments, I would say statutory text as well. This kind of gets to Title VII and the Bostock decision, should all, when in areas of doubt, be construed to err on the side of the purpose, what Blackstone would call the ratio legis, the reason of the law, the purpose of the American constitutional order, which I do root in the profoundly kind of Anglophilic, common law-based, common good-oriented, telos substantive ends of the preamble. So hopefully that clears up just a little bit in a very brief rebuttal.
Josh, thanks for that. So let's now begin a more open dialogue. I want to start by returning us to the words of Judge Bork. Judge Bork once wrote that no amount of philosophy, be it natural law or originalism, can control a lawless judge. The difference is that natural law invites a judge to be lawless, while originalism requires that he actively dissemble in order to be lawless. Josh, I'll turn it to you first. What did Judge Bork get wrong in that sentiment, and how do you see your theory as correcting the concerns that he raised?
So there's really not a whole lot in that exact quote that I object to. I don't actually consider myself to be a natural lawyer, or let alone a natural law scholar. I do not take the same approach to jurisprudence that true kind of natural law icons, the likes of Harry Jaffa necessarily took. Although I don't want to misconstrue Jaffa either. I mean, even someone like he would understand that you can't get, if the text is clear, it's an open and shut case. Okay, I think the issue here is twofold. We're talking here a lot about kind of the zone of ambiguity, the zone of reasonable interpretation, the construction zone here. What I call common good originalism operates twofold. It takes what Hamilton and Marshall would have referred to as the axioms, the self-evident truths without which the entire constitutional order cannot be understood. James Wilson was another kind of 1790s era early Republic figure who would have understood this quite intuitively, in contrast perhaps to Jefferson and some of his closest colleagues. And they would have understood that the words on the page cannot possibly be understood unless you have some rudimentary understanding of the very first principles upon which all of this is built. That gets us back to the common law. That does get us back to the Declaration of Independence as well. It kind of gets back to a tangential point of mine, which is kind of a general decrying of first-year law school curricula and how they teach the common law without teaching the Bible or any kind of natural law principles whatsoever, which I think is kind of a farcical approach to first-year legal pedagogy, but that's really neither here nor there. And I think in general, this notion of just again, Judge Bork's comment there, I don't take particular umbrage to it, but to the extent that it is saying that we can't consider anything whatsoever, and that there is a right or wrong answer here, and that right or wrong answer is always clearly going to be within the four corners of the page that you are staring at, without necessarily getting to the Hamiltonian Marshallian axioms, those self-evident truths. That is where I would pick a bone there. And of course, this is not getting into the construction zone debate. What do you do within the zone of ambiguity? Really, I don't view common good originalism as being all that different, actually, from libertarian originalism's presumption of liberty. Rather, though, than a presumption of liberty within the zone of ambiguity, whether than this kind of aggressive Ninth Amendment privileges or immunities clause, et cetera, I would just orient the zone of ambiguity to the telos of the American regime, the ratio legis that Blackstone called it, the reason of the law, which is there in our founding documents, in the preamble in particular, I think.
And if I can pick up on that point that Josh is raising here, is there really no room for debate among originalists? It seems like Josh is arguing, let's find the best reading of the Constitution as originally understood, perhaps informed by Hamilton, Marshall, Wilson. Why would that sort of historical inquiry be objectionable to an originalist?
Well, it's not. And I must say, I'm still having difficulty understanding what common good originalism is. This discussion is far too abstract for me to get a hold of. I'd love to hear concrete examples of where Josh thinks conservative originalism has gone wrong. Look, Hamilton, I view myself as an adherent to Hamilton's views and to Marshall's views. Hamilton in Federalist 78 made quite clear that what the judges do not have authority to override democratic enactments absent an irreconcilable variance between the statute and the Constitution. That same understanding is what Marshall grounded the very exercise of judicial review in Marbury versus Madison. I'm surprised to hear Josh seem to impute to Judge Bork the view that originalism always yields clear answers. I don't think that was Bork's view. It certainly wasn't Justice Scalia's. Again, on a lot of the hot button issues of the day, yes, it does provide clear answers, but there are other matters on which it can be quite difficult to know the clear answer. Let's take, for example, an issue that I first raised 15 years ago when I thought I was so far removed from any real world debate that people's political biases wouldn't influence their judgment. And that was the provision in the Constitution that in order to be eligible to be president, you must be a natural born citizen. Now, it turns out that in all the controversy that's arisen over different presidential candidates since then, nearly everyone has understood the core originalist concept that we need to look to what that term meant at the time it was adopted. Even then, though, there are debates over just what that means. And it's not entirely clear just what its scope is. So, but again, it's entirely fine to look to Marshall's understanding, Hamilton's understanding, especially when we try to see what that understanding is grounded in. So I'm not sure at that level that Josh and I actually have any difference. No difference that I see, at least.
Well, let's on that point, maybe that's a good opportunity, Josh, for you to respond to Ed's inquiry. What's an issue or two that meets Ed's concern where you think that common good originalism would yield a different result than, say, the originalism of Justice Scalia?
Sure. So, you know, I don't necessarily want to get into kind of Scalia specifically, but I understand that he plays a large role in these debates. So I'll try to do that best I can. Look, I can think of at least 4 examples right off the top of my head that I think common good originalism would not necessarily ipso facto lead to a different result, but would at least plausibly and perhaps persuasively support a different result than many leading originalists today would agree with. Let's call it 5. Okay, and I'll do this very quickly. Start with the First Amendment, free speech. A lot of conservatives have kind of rallied around a fundamentally libertarian view of speech. This kind of was encapsulated, of course. I am not calling Anthony Kennedy a conservative, of course. But he has this line in the Citizens United case where, the answer in our tradition to some speech has always been more speech. This is a fundamentally kind of Voltairean, Enlightenment, liberal view of speech. It is not a conservative view of speech. It's certainly not the common law's view of speech. I think the more conservative view of speech, and the likes of which common good originalism, based on kind of the values of the preamble as opposed to individual liberty maximalism, would robustly support, was espoused by Justice Alito in his dissent in the Snyder versus Phelps case. That's kind of the shouting for epithets at the military funeral from the sidewalks case, a deeply courageous solo dissent from Justice Alito, I think. He similarly dissented in an 8-1 opinion in the Animal Crush video along very similar lines. Freedom of the press would be another example. Now, this gets a little dicey because, if I'm not mistaken, Justice Scalia, to his great credit, was a vehement critic of New York Times versus Sullivan. But to the extent that especially our more libertarian-leaning friends would support at least the policy outcome in New York Times versus Sullivan, I think common good originalism would offer much more emphasis, and it would much more clearly and robustly support the opposite conclusion, the conclusion that New York Times versus Sullivan was an utter atrocity, a total misconstruing of the role of defamation law as it pertains to the First Amendment in our constitutional order. The Fourth Amendment would be another area here. It's kind of vogue these days, especially in kind of Cato Institute for Justice worlds, to take a much more kind of libertarian view of the Fourth Amendment. Justice Gorsuch, who is a sometime libertarian hero, had that quote unquote dissent in the Carpenter versus U.S. case in 2018. I think common good originalism would take kind of a much more deferential approach, for lack of a better term, to law enforcement, of course. There, 2 quick other examples, both pertain to the 14th Amendment. Of course, there's kind of the hot issue of the day right now, which Ed, of course, is himself very involved in, which is constitutional personhood. This conversation, of course, launched anew by the eminent natural law scholar John Finnis in First Things Magazine last month. I don't think common good originalism is necessarily decisive or ipso facto determinant on this particular debate. I do think it lends much greater support than positivist originalism does to the John Finnis, Josh Craddock position, that the Equal Protection Clause mandates that a state cannot discriminate between those born and those unborn when it comes to homicide laws. And then a final, just very quick example. Again, I don't think this is determinant, but it does, I think, lend much more a much greater worth, much greater salience, much greater value to kind of the John Eastman position, if you will, on birthright citizenship as it pertains to illegal aliens in the United States. And I say that, of course, as a former clerk of Judge Ho, who disagreed a lot with John Eastman on this over the years. I do think common good originalism would at least more readily support the John Eastman, he's not the only one, but Richard Epstein actually agrees with this too. The Eastman-Epstein stance, if you will, that illegal aliens born on U.S. soil do not necessarily have citizenship under Section 1 of the 14th Amendment, simply due to the fact they were born here.
Ed, does that answer your question? And if not, please respond.
Well, I appreciate those examples. There was, I think, a fair amount of fudging as to whether something would just lend some support versus compel. I think in some of the examples, what we really see is the difficulty of, what precedent you're going to be ready to overturn. And I think that's a completely separate issue from what your interpretive methodology is in the first place. So, and I don't know, I guess I see a certain mix and match here. I'm not really sure I see the principle and why you'd be deferential on the Fourth Amendment, but say much more aggressive on 14th Amendment personhood. I will say that on that question, which is one that morally matters greatly to me, both John Finnis and Josh Craddock and Mike Paulson before them present their argument in originalist terms. So, and very much in positivist terms. And indeed, Josh, for all his criticism of positivism, is eager to invoke the positivist crutch of the preamble as the vehicle for carrying his substantive preferences. So we could walk through any of these in more detail, though I haven't studied the question of birthright citizenship, but it seems to me that Josh's ultimate answer is that, as he put it before, where there's this construction zone, there's room to adopt whatever ad hoc judgment you want, and therefore common good originalism would enable you to do things that you want to, that you can sort of justify in terms of the 7 vague goals of the preamble. Well, I don't believe in government by judiciary. I don't think that is any different from Ronald Dworkin's position.
Josh, is it possible that this is just judges doing originalism wrong? Much has been written about law office historians, the inability of the legal mind to perform what is really a historical research function. Do you see room for improvement here that might answer some of the gaps, or is this simply a cause that needs to be modified?
I think after the Bostock decision, it is clear at this point that this avowed positivist, kind of implicit Jeffersonian strict constructionist form of methodology that has kind of been bequeathed us by our originalist forebears is a feature, not a bug, to some extent. I greatly sympathize with Senator Josh Hawley, who spoke on the Senate floor the day after the Bostock decision and basically said, if originalism and textualism are leading to this result, then maybe we need to think about what we stand for in kind of the first instance here. Now, again, I point to Bostock for a lot of reasons. Now, this obviously has a lot to do with judicial selection. We can always talk about what we could have done better last time. In Justice Gorsuch's particular example, there was the Castle case from the Ninth Circuit where he was sitting by designation, which kind of foreshadowed his apostasy on the Bostock decision. But that's really kind of a separate discussion here. I have lots of thoughts on how we can kind of improve the judicial selection process. The point here, and people have written about this for decades, by the way, about the kind of shortcomings of conservative Republican Party nominated Supreme Court nominees. We're all familiar with the greenhouse effect. We're all familiar with everyone who kind of shifts to the left over time. I mean, obviously, the disappointments are legion. There are just too many data points to point to. So at some point, we need to kind of ask ourselves whether this actually is perfectible or whether it is even close to being perfected. And I recognize that by kind of touching the proverbial third rail of jurisprudence itself, that I am kind of, even if I'm doing so in a very moderate, kind of mild standpoint here, I recognize that I'm alienating a lot of people. But I think it has to be part of the equation here. There are lots of things that I would do for judicial selection. There are lots of things that I would do in terms of kind of eschewing administrative law centric judges. I would look more to the literal heartland. Justice Barrett was a great example, I think, of that, obviously. There are any other number of things that I would do as well, as far as kind of poring over the record, looking for full spectrum conservatism, not just this dorky occupational licensing, qualified immunity, libertarian stuff. There's all sorts of stuff that I would do there as far as the actual kind of nitty gritty judicial selection process. But I think it is wholly appropriate to ask, especially at a time and place where, going back at least as far as Caroline Products footnote 4, the implicit intersectionality of Caroline Products footnote 4, at least since then, the legal left has been fighting us with two hands. And due to this notion of positivism, for better or for worse, we are fighting with one hand behind our back. Now, if the end goal here, if the end goal are kind of liberal paradigms, not progressive, but liberal paradigms, if the end goal is neutrality, is kind of a substantively neutral rule of law, then I guess that's maybe kind of sort of okay. If, like me, you are first and foremost a substantive conservative who cares about our millennia-long Anglo-American inheritance, the substantive values of justice, of course, going back all the way to Aristotle and those like him, if that is what you are primarily motivated by, I think you have to be willing to tweak around the edges of our jurisprudential framework, especially in a way that I'm outlining here, where that tweaking around the edges is actually directly in line with the telos of the American regime as expressed in the preamble.
Ed, I want to return to a point you've made earlier, which is what results from originalism. And part of that is the majoritarian process of lawmaking that comes from elected legislatures. There was an interesting recent Harvard Law Review note, which you've no doubt seen, that talked about how the Constitution might not apply to Indian reservations. And if so, there could be more than 550 tribal governments where the sort of neutral sovereigns that we are looking for could embrace the notions of original constitutionalism. Why do we think there hasn't been more active lawmaking in spaces like this, a place where arguably the Supreme Court's decisions on questions like abortion never come into play?
Well, that's an interesting question. So why aren't we originalists looking more at litigating on Indian reservations? I think you could ask the same question, why we're not looking more at litigating in Mexico or in France. I happen to notice today that a very liberal Deputy Solicitor General in the Clinton administration he's not Indian at all, but he's Chief Justice of the court of one of these Indian reservations. Look, if folks want to figure out how to promote originalism within Indian territory, I'm all for that. But I think we have a bigger mission right now of promoting it, continuing to advance its cause outside Indian territory in this country. And I do want to just respond to a couple things that Josh said. He's mentioned Bostock a number of times. Of course, the dissents in Bostock by Justice Thomas and Justice Kavanaugh and Justice Alito. Thomas joined Alito's dissent, I believe, were powerful illustrations of sound textualism. So you cannot indict textualism by pointing to a bad exercise of it any more than you indict the craft of carpentry by pointing to a shoddily built house. And on Josh's comments on the judicial selection process, I just have to, throw up my hands. I mean, I've been involved with this for 30 years. And if you don't recognize that the tremendous progress that we have made in that time, progress leading to Justice Barrett last fall, if you don't understand how difficult every stage of that was and see the constraints that led to Bork being defeated, in 1987, and forced us to make picks, force presidents to make picks that we wish hadn't been made. Look at the near disasters that were averted. Things are so much better now because of the fights that we have fought and won, fights that have reoriented the parties around judicial philosophy. Our getting rid of the filibuster on Supreme Court nominees finally during the Gorsuch process, something that had it not happened, we never would have had. We wouldn't have been able to fill the Ginsburg seat at all, much less fill it with someone as good as Justice Barrett. So I just see this naive view that, of course, we could do things better now, and there are all these mistakes made in the past, without understanding the constraints that existed then, without understanding that, the process is not perfectible. It's never going to be perfect, but we're sure doing a lot better now than we did in the past. And this is not the time to abandon ship.
Can I respond real quick, Justice Matey?
Absolutely.
Judge Matey, excuse me. I'll respond very quickly because we obviously do want to move on here to Ed's 2 points there. One is, Ed is fond, and he's probably the only one who makes this point of kind of criticizing my focus on Bostock because how can you, the whole carpentry analogy here. Here's the point. The point is twofold. One is when you emphasize originalism as being this avowed positivism that pays no heed whatsoever to kind of the overarching purpose, the telos of governance, the declaration, the preamble, natural law, any concerns like that whatsoever, the axioms that I referenced earlier that Hamilton wrote about in Federalist 31 or 33, Marshall references in McCulloch versus Maryland. When you strip that away, when you strip those tools away, you are far likelier to lead to a high-profile defection, and that was a high-profile defection. This was Neil Gorsuch has a PhD, of course. I mean, he was effectively a natural law trained human being. I mean, I think
exactly. If I can interrupt you on this point, Josh, but look, he was trained under John Finnis for 2 years. I'm not blaming John Finnis for Neil Gorsuch. I mean, but you could as easily blame natural law for Neil Gorsuch not understanding, that the difference between a man and a woman, using the transgender rhetoric that he did. I just don't think it's fair to lay that, at the feet of positivists.
Well, I don't blame John Finnis. I blame the originalists who have taken the necessary tools away from purportedly well-trained judges to actually reach conservative outcomes in a way that comports with the telos of the American regime. And look, the other point here is when we emphasize this notion of positivism, don't worry about the Declaration, don't worry about the preamble, there's only one right answer. That is a very slippery slope to Gorsuch's opinion in Bostock. This notion, of course, we're getting down the road of a no true Scotsman fallacy, of course, no true Scotsman, no true textualist. At what point do we just throw up our hands and say, again, like Josh Hawley did on the Senate floor the day after Bostock, what do these terms mean if all we're doing is literally every time a major conservative defects, not proper originalism, not proper textual? Well, you know what? Maybe there's something wrong with how we're formulating. Maybe there's something wrong and it is a feature, not a bug. Okay, that's the very first point. The second point, with respect to my purported naivete, and admittedly I am only 32 years young, I look back at the history of the modern conservative legal movement here, and it appears to me that the two Republican presidents who have been most successful, and there have been, by my count, 4 since this wonderful organization was founded in 1982, Reagan, Bush 1, Bush 2, and Trump. It is entirely possible that the two most successful Republican presidents, looking back at strictly Supreme Court nominations, are actually the first two. Reagan, of course. Reagan, of course, gives us Justice Scalia, who, for all my criticisms of his positivism, was obviously a fabulous justice. And Bush 1 gives us Clarence Thomas. Now, obviously, we know all about Edith Jones, who should have gotten that seat over David Souter. We're not going to relitigate that with John Sununu. I'd rather not talk about any of that. It's just going to kind of get my blood pressure going. Bush 2, of course, gives us Sam Alito, who's a fabulous justice, and Chief Justice Roberts, who was just a new David Souter. So comparing Bush 1 to Bush 2, we basically can effectively, from my perspective, at this point, call Souter and Roberts equals. Then we're kind of comparing Alito to Thomas, apples to apples. The Trump presidency, up until maybe last term, I might have said that he was probably the most successful. At this point, that is not even remotely obvious to me at this point. Brett Kavanaugh is sitting squarely in the middle of the court. He votes most frequently with the chief. Maybe at this point, he will vote more frequently this term with someone like Justice Barrett. Justice Gorsuch is a libertarian in conservatives' clothing. He is defecting left and right. The Sessions versus DiMaia case of April 2018 was a complete and utter atrocity. His quote-unquote dissent in Carpenter versus United States was straight out of the Cato Institute's playbook. Bostock was obviously an epic dissent. He has a Thomas-esque view on stare decisis, which I appreciate, but he's basically just a libertarian. Justice Barrett, it's obviously way too early to tell. We need to see what actually happens. But, as Josh Blackman said in a Reason.com post last week, her performance on the shadow docket is placing her squarely in the Kavanaugh-Roberts camp. We know obviously what happened on the election cases. There was recently kind of the free exercise case. So I am not particularly optimistic about even the Trump nominees, all things considered. So if this is what 40 years of lessons learned and success looks like, I would suggest that we should probably define our expectations up, lest we self-abase ourselves into into oblivion.
There's no question, Ed. And I was going to turn it over to you.
Yeah, let me answer this. I mean, come on. You didn't even mention Justice Sandra Day O'Connor. my God, the idea that, I'm not faulting Reagan necessarily, but he went 1 for 3. He gave us O'Connor and Kennedy, who were on the court forever. The idea that you compare, Roberts for all his shortcomings to Souter, no way. Souter was a hardcore liberal from his second year on the court. There's no comparison at all to Roberts, who is more conservative than Kennedy was. Look, we'll see what happens going forward. And it is too early to tell. And look, I share your deep disappointment over Bostock, but I just think your comparisons here are utterly out of whack. I find them unbelievable. Again, I think the world of Justice Thomas, but Souter and Roberts are not at all comparable.
Let me interject here, if I could, to take us in a slightly different direction from appointments to something, Josh, you've mentioned a couple of times now, and I think you've dealt with as well, and that's how textualism is implicated in the state. We see a lot about not only whether textualism should be followed, but which kind of textualism, a point that Justice Alito wrote about just last week, whether textually grounded arguments miss too much. So how do you see the interaction between textualism and originalism, Josh, with the theory that you're expounding?
Oh, I can answer that in 10 seconds. I use the terms effectively interchangeably. I don't think there's really any difference at all between the interpretive enterprise when it comes to constitution or a statute. I think I have some paragraph in my paper coming out next month where I actually kind of offer some half-hearted criticism, actually, of the notion. Originalism has in many instances just gotten totally over-theorized from my perspective, and that's kind of, I think, why we're down the rabbit hole that we've got into, because we've kind of forsaken common sense for over-intellectualization, over-theorization. And, it's kind of similar to this whole kind of argument about whether there's a difference between interpretation and construction. It's just totally missing the forest for the trees here. So I personally use the terms originalism and textualism basically synonymous with one another. I think textualism is just originalism for statutes.
I don't want to take the entire conversation. I know there's many audience members who are waiting to be heard from. So a reminder that if you'd like to ask a question, raise your hand, and we'll turn to the audience questions in just a moment. Ed, while we're waiting for folks to raise their hands, any thoughts on the distinctness of textualism as an enterprise and Justice Alito's criticism last week about how the methodology may now be operating?
Well, I have to say I'm not familiar with just which criticism you're referring to, so I'm not able to answer that. I know in one opinion he was, I guess, disputing the way that canons were being used overly mechanically, and there's lots of room, I think, for that criticism. Look, I agree with Josh. People can use the terms obviously as they see fit, but I see these as terms basically describing the same thing that arose in different contexts to counter different fallacies. So textualism arose as a term to counter purposivism and pragmatism, and originalism arose to counter living constitutionalism. But the goal of each is to discern the meaning of the text at the time it was adopted. It's possible that that the sort of evidence you look to can differ a little bit for originalism versus textualism, but I think conceptually they're very close, if not identical.
So let's turn to some of the audience questions. I appreciate those who are chiming in. Let's start with William Sawyers. Your question for the panelists.
Hello, can you hear me?
Yes, we can.
Absolutely. So this is a question for Josh. Basically, I'm a little unclear on where you're getting these substantive beliefs. Like, how do we know the founders or the preamble hated the New York Times, loved cops, opposed abortion, and worried about illegal immigration? You talk about telos and purpose and preamble, but then on the other hand, you talk about not wanting to fight with hands tied behind their back. So what takes precedent? Your substantive conservative beliefs and how are we actually grounding these in the text, in the preamble? How do we know the founders actually favored these substantive outcomes?
Okay, great question. So let's just read the preamble. Okay, let's be on the same page here. Quote, "We, the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity, do ordain and establish this Constitution for the United States of America." Now, again, what the role that the preamble plays, obviously, is open to robust debate. John Grove recently, one of my critics at the Law and Liberty blog, criticized me for relying too much on it. I think Ed would as well. But if you take the view that I do, that this is the clearest emphasis on what I call, to borrow the from Aristotle, the telos, the purpose of the American regime, you look at this and you say, this is not about individual liberty at all. Okay, there are 7 ends of governance here. The last 2 are the blessings of liberty to ourselves and our posterity. But as I intimated in my earliest comments, that's the closest you're going to get to individual liberty. But even that is actually not about individual liberty. It's securing the blessings of liberty, where liberty itself is an instrumental means to the substantive ends of those actual blessings. So what does this mean in more concrete terms, when we're talking about establishing justice and the general welfare and a more perfect union? We're talking here about kind of more nationalist, common good, health of the whole, communitarian-centric goals here. These are what they were most concerned about. They were much more concerned about these sort of goals in contrast to kind of the individual liberty maximalism that is too often, I think, pervaded not just the conservative legal movement, by the way, but the conservative movement in general. I think kind of going a little more abstract for a second here, kind of the fusionist consensus, I think, to a large degree, has been overrun by libertarianism. I think libertarians have largely crowded out more traditional conservatives. When if you look at the preamble, it was really quite the opposite there. Now, I'm not going to tell you that, I'm not going to take your question literally. I'll take it seriously, but not literally, so to speak. But it's not like they obviously would have heard the New York Times, which is not a paper. But look, there were obviously prosecutions for blasphemy, as late as kind of the early to mid 1800s here. On the common law of defamation was extremely robust. No matter what you think of kind of the Alien Sedition Acts, those acts did exist, and they were obviously robustly debated at the time. So I just think an issue after issue, if you look carefully at it, and again, I cited kind of the Kennedy line in Citizens United, the fact that even fabulous originalists like Justice Thomas, Justice Alito took the wrong view in a case like Snyder versus Phelps. Time and time again, on issue after issue, it seems that the quote unquote conservative originalist position has just gone to individual liberty maximalism, when if you look at what the founders actually believed, it was extremely far from that. Even James Madison, by the way, who obviously disagreed with Hamilton any number of issues. His most famous Federalist paper, the Federalist number 10, uses the term public good like 5 or 6 times if you control F-ed, and he used the term common good one other time. Madison, Federalist 57, refers to justice as the end of government. These were common good oriented statesmen. They were much more profoundly conservative than today's historical revisionists realize.
Our next question is from Matthew Nielsen. Matthew, could you tell us your point?
Thank you, Honor. My question is from both of your positions. Could you address the recent, like with the current administration, with the recent executive order about trying to look, this commission on the Supreme Court, and this idea specifically of circulating justices between the Supreme Court to the lower courts and vice versa? How would the argument for originalism or common good originalism look at that?
Well, I'll take a start. I mean, look, I think that the method of selecting justices, including some of these ideas about rotating appellate judges onto the Supreme Court, I think that issue is, as a theoretical matter, completely distinct from the question of how the justices should interpret the Constitution. Might there be some practical overlap? Yes. Might obviously the interest on the left in pursuing these court packing or other measures, it's aimed now against a court that they see or fear will be too conservative. So it's it's obviously ideological in nature. But I do think that at the level of theory, the question of who the justices are and versus how they interpret the Constitution, those are distinct, and that good justices ought to adopt whatever we establish to be the best methodology.
Yeah, I think that's clearly right. Institutional allocation and interpretive methodology are two distinct questions. And I mean, because of common good originalism, I get accused a lot of being like a judicial authoritarian or something along those lines. Far from it. I wrote a whole academic paper last year on judicial supremacy and my staunch, opposition to it, citing people like Lincoln. So these are two totally distinct questions from one another. If I'm pontificating kind of off the cuff on the merits of the question, it strikes me as probably a good idea. If for no other reason, then I like the fact that there would be justices kind of intermittently subbing in who don't literally live in the Beltway. In fact, kind of one of my ideas for fixing the judicial selection process is that I would literally place like a 10-year moratorium on literally moving out of like a 30-mile radius of Washington, D.C. on not being able to be nominated to the Supreme Court. So the fact that we're kind of getting in more of real America, so to speak, that strikes me as kind of just an inherently good idea.
Let's have in mind where Justice Scalia and Justice Thomas came from.
Now, where did Justice Alito come from again? I seem to not be able to recall. Let's take one more question before we turn it back to Josh and Ed for just a brief closing comment. Let's go to Isaiah McKinney. Isaiah, your question.
Hi, I wanted to hear from both the panelists on this. I tend, since there's been a lot of talk about tonight about conservative versus libertarian ideology, and I would find myself as probably a very libertarian with a strong, but also the strong conservative streak. But I want to know why we should, I don't think these two, while these ideologies are very distinct, I don't think they should consider themselves as enemies so much as, but I think there's a lot more in common than they have opposed to each other. So I wonder why wouldn't we want to embrace a judicial philosophy like originalism that both of them support? And then, although we're going to come to slightly different, they're going to have different results at times, as all justices do. Why don't we do that and get more of a common and pick, just follow originalism, where we're going to get more of a general consensus on the law, rather than saying one view, conservatism, is better than all the rest.
Well, look, I actually share Josh Hammer's concern that my libertarian friends have far too often been opponents in important pieces of litigation. Not just at Obergefell, but Windsor, where I thought there was a ridiculous brief that lots of high-profile libertarians signed on to, completely misunderstanding the core questions of federalism at issue in DOMA. So, look, there obviously are significantly different policy preferences that, say, social conservatives have from libertarians. Insofar as Josh is complaining that social conservatives are less ready to read into their constitutional interpretation, their substantive preferences, than libertarians are, I think his complaint has merit. That is, I think it's a sound observation. Whether that's something that social conservatives should be faulted for or credited with is a different matter. But I think it is true that social conservatives have not adopted a view that the Constitution entrenches their policy preferences on issue after issue after issue in the way that progressives and libertarians often have. So, look, I'd see, to continue the theme of this evening, I'd see conservatives and libertarians perhaps as sparring partners who might, sharpen the skills of the other, but ultimately their approaches are very different.
Yeah, this is probably the most that Ed and I will agree all night, which is great. I don't disagree with very much at all that he just said. If you go back to the kind of origins of the conservative libertarian alliance, obviously this kind of gets back to Frank Meyer and National Review and Fusionism and the three-legged stool, Barry Goldwater, Ronald Reagan, et cetera, right? A lot of that was kind of based on like a strategic tactical alliance. I mean, from a crass political term, obviously kind of the Reaganite alliance was built to ultimately defeat the Soviet Union, which it did quite successfully, of course. Look, fast forwarding, 30, 40 years in the year 2021, a conservative libertarian alliance, especially as America is undergoing what appears to me to be a political realignment of sorts, actually. This conservative libertarian alliance to me makes less sense than it ever did. In fact, I personally am actually sympathetic to my friend Arthur Millick, who's the executive director of Claremont Institute's new DC Center for the American Way of Life. Arthur said in a podcast recently that from his conservative perspective, he, at this point, rather that he would prefer the libertarians just go and outright join the left, and that conservatives try to make common cause with kind of traditional left liberals, the Barry Weisses of the world, more so than kind of libertarians who at this point just disagree with us more vehemently, it seems, as anyone who's ever been on Twitter can tell, than anyone else out there. I'm very sympathetic to that. And I just don't really see much point, frankly, in continuing on this dalliance between conservatives and libertarians that from a conservative perspective increasingly does not serve us well.
Hey, libertarians are a lot nicer to me on Twitter than some common good conservatives are.
And with a rare moment of agreement, it seems like a good place to end our conversation to the night. Like any good debates, this one could go on and will go on much longer. I want to thank Josh and Ed for this amazing battle. And I want to take the opportunity to shift our gears at the end here to the presentation of the 10th annual Feddie Awards. Now, while the Feddies are usually presented in person during the National Student Symposium, the virtual program this year at Penn Law precluded a live ceremony. So we are honored to use tonight's event to announce this year's recipients. My congratulations to all the finalists and the winning chapters. Now on to the awards.
And that will do it for tonight's event. Thank you to all our attendees and panelists. Be sure to join FedSoc next month for episode 10, Is This How Liberty Dies? On the legitimacy of the empire, featuring Obidan Suher, a rebel sympathizer from the far reaches of Alderaan University School of Peace, versus Darth Maul Massouf, associate professor of law enforcement at the Imperial University of Coruscant. Our event will be arbitrated by Grand Marf Ashley Baker, and the designated trade association arbiter. Tuesday, May the 4th, be with us at 8 p.m. Eastern. Congratulations again to all of tonight's Feddie Award winners, and go Bucks.